didn't want to be behind the podium. So, all right. Well, thanks for coming. My name is Rick Pyfer, and I know a number of you here. And I was asked by Sarah to come and talk on some topic, and I thought, well, I'll talk about what is probably the easiest thing to talk about, and that's our practice. And can you shut that off for me? I can't get Siri to shut that thing off. Keith's my tech helper. So Keith Storar is in the audience. He's my law partner. Dubeck, Pyfer, and Storar is our current practice. Some of you may know Pat Fox, who was my partner about 10 years too, and is on his own now practicing and doing mediation. If anyone needs a mediator, Pat's gone through mediation training and set up a business doing that. And he also lobbied for MTLA. But I wanted to give a little background about myself and as it relates to the firm and what we built in the firm. Keith, as I said, is a partner right now. It's myself, John Dubeck, and Keith. We also brought in an associate, Jonathan King. He couldn't make it today. He had a conflict. But Jonathan's an associate in our law firm. So we've had 4 lawyers in the firm for quite some time. John and I joined up in '81, and we have a general practice. When I first started the practice, we were doing a variety of things. I ended up doing some criminal defense work, and I tried a criminal case that was pretty notorious, had a front-page headline, and I got a defense verdict, so they said, okay, we'll make you a partner, which was cool. And about 4 months later, then I was a partner with these guys. It was Small Hatch Dubeck and Pyfer then. We were on Fuller Avenue. And we made several moves. We remodeled where the urgent care is on Neal Avenue. Then John and I, about 20-plus years ago, bought the building we're in now by Benny's, and we've been there ever since. Hey, Bruce. So anyway, I was a year at Smith Law Firm, where Bruce Spencer here used to be, before I came around the corner and joined John. And then I became a partner. But what I wanted to talk about is generally what goes on in a general practice firm, particularly our firm, and maybe some hints I think that are helpful. As Keith and I share cases and work together, he learns a lot of these things as we talk about them throughout a day. But I tried to capsulize what I think are some of the important points. So I did a little bit of an outline here, and it's 3 pages, and the last page of it is actually a kind of a list of practice pointers, and it was Rick's words of wisdom or something I think Keith had, and we had it posted for the young guys, but those are just some general philosophical things, but also important pointers, I think, in practice. And, I might go over those real quickly first, but they're kind of ground rules in practice. Any practice, any job you have, you want to have fun at it, so it's important to have fun. You're going to live longer if you do that, so enjoy where you work and who you work with. And, when you can find light in something, do that. When you can find a joke a day or whatever, have some humor throughout the day. Get the money now relates to our practice. That's designated for personal injury attorneys who, what I mean by that is don't wait around. If you can make a recovery for somebody, don't delay it. Do it as soon as you're able to within, the parameters I'll talk about in a minute in our practice. Be firm, but don't show your clenched fist, and that relates to adjusters. In our business, we're dealing with claims and claims adjusters, defense attorneys, and by the clenched fist, you don't have to get in a fight right from the start. Some attorneys have that MO. I never have. If you get along, you're going to do better. Pat Fox had this wonderful way of addressing every letter, the first line. I hope you're doing well in his letter to an adjuster and attorney. So he'd start them all that way, and I don't go that far. I do hope they're doing well, but I think kinder, gentler works better. But be firm and be assertive, but without always trying to get in a fight. Be honest in every representation. Well, that goes to your clients, fellow attorneys, everything. Don't answer with a speech. If a short answer will do the trick. Don't go on and on. Don't we all hate when somebody doesn't shut up and just get to the point? So if it's an issue that you're dealing with an adjuster or somebody, get to the point you need to make, get it done. It's all about efficiencies, really. And then the 7th one, all people weight your word on the scale of past performance. It's hard to regain credibility after a lie is told. I had a lawyer, when I was interviewing, Jack Luxon, was a good friend of my dad's. I didn't get a job with him, offer from him, but he sat me down and said, I don't have a job for you, but I got advice. He said, whenever you're talking to lawyers in this town, make darn sure that if you have a deal, you're talking about some kind of agreement, write it down, don't forget it, and don't ever misrepresent to another lawyer, back off an agreement you made. So keep your promise, in effect. And those are really important. That's important advice. As I said, it's hard to regain credibility once you are caught in a misrepresentation. In our business of dealing with numerous insurance companies and other defense attorneys, we've kept our powder dry, I think, in a lot of ways, John and I, over the years by doing that, by being credible, by being honest, by not backing off an agreement. One of the biggest areas, and I just had this happen, had a mediation coming up in the mediator, and I had been going back and forth for 3 months on a negotiation. And from the get-go and early on in practice, I had a buddy named Jim Higgins, who I went to high school with. He was Farmers in Helena. And Jim and I got crosswise because the whole idea of when you're settling a claim, is this new money or inclusive money? So there's advance money that's paid on a claim, and maybe $5,000 has been paid, and you're settling for $25,000, or you make an offer of $25,000. Is that new money, or is that inclusive of the money paid? So I have always, because I've gotten crosswise on that, made a really big point of never. I always am talking new money in my negotiation with an adjuster. It's always new money. So an adjuster, we had the mediator, got our brochures. He said, hey, I understand this is inclusive money, not new money. And so I said, nah. So I ended up getting a little bit out of sorts, called the adjuster. 30 minutes later, she said, I'm sorry, went back to my emails. You're right, it was new money, and that's the way we'd done it. But keeping your promises. Faulty recollection can be saved by regular notations. Write promises down. If you're making an agreement promise, it's email or whatever, write it down, make a note. Email's so great now because we have a much better way of keeping track of things. Lawyers in private practice, one of the biggest traps we have, I found, is people not getting back to people, avoiding a client. Maybe you don't want to, but you got to get back to them. So answer phone messages promptly is my point there. If you didn't want to take a client on in the first place, which I'll go through when I go through my little outline, you should have done that in the first place. So now that they're your client, deal with them. And if it's something that can be passed off and staff can have them answer it, but do reply. Don't put people off. Don't lead people on to believe that they have something when they don't. That's very dangerous. And I in my beginning outline, I do talk about selection of people for cases. That relates a lot to what we do in practice because ours is all about intake of clients. Ours is all about people knocking the door want us to handle a claim for them. And the kinds of claims we handle, I'll go into that in a minute. But when they come in, you don't want to suggest that they have a big deal of a case. You don't want to make it bigger than it is. They're always looking for those signals. And so it's important to really be honest about it and not lead people to believe they have something they don't. And don't take the case that's questionable. It's pretty obvious. You must believe in the case to sell it and its merits. All the way through, you got to believe in them. You got to believe in the credibility of your client. If you get some reason to disbelieve them, then talk about that at the last point there. That applies to liability and damages. Serving the community, I think, is really important for any private practitioner. We make a good living as lawyers, and in our business, in personal injury, if you got a successful practice, you're usually doing well. It's really important to give back, and I think it's really important for any lawyer to give back because we have part of subsidized into our practice by, the state and the taxpayer. So it's important to give back. And I'm a firm believer in promoting service to the community by giving, treasure time, and all those things. So try to stay involved. And I personally try to encourage that with people who come to work for us. Don't waste time on garbage issues. Well, in cases you'll find that, you can start. Defense attorneys are paid by the hour. In our practice, we aren't paid by the hour. So this kind of goes to the new attorneys in our place. And I'm just kind of telling them, hey, you don't have to dive into something that's not going to get anywhere for you. Don't waste time on that. We're not billing by the hour. Get to the points that are important. So don't get hung up on issues that don't really have a bearing or relevance. And don't hesitate to dump incorrigible or overly demanding clients who are impossible to satisfy. You'll never win them over. The point there is that you're not obligated, if someone lies to you in a case, obviously you don't have to, and you find they are not credible, they're lying about things, you can confront them and say, hey, I'm sorry, but, in our business, it's important to know a person's back history. We get an auto accident case in. They have to tell us as much as we can find out about their background of injuries. We need to know what pre-existing things they have, because those will always come up to haunt you, and insurance companies will find them out. So we need to know everything. And if they purposely avoid telling us something, that's a big red flag. And at some point, if before you file a complaint or get that far down the road, if you feel a person's, and you're in our business, not being honest, you do have a right to notify them that, but you have to be, of course, careful to follow the rules of transitioning to someone else, making sure that you're not jeopardizing their claim, and all those things that apply. So anyway, the first part of this, I started on this first outline. I just talked about building blocks of a firm. The first thing is, of course, who are you going to work with? And if you decide you want to go out into private practice and do that rather than state work and establish a practice, one of the first things is, who's that person going to be or persons that you're going to work with? And I think it's really important to have common values. You may not have all the same values, but John Dubeck and I was fortunate enough to have him walk around the corner to visit me from Smith. And I was at Smith, and he was around the corner on Fuller and said, hey, we need somebody. Would you like to join? And I talked to him about it and what they did. And John and I we have a Catholic faith in common, different types of practices of our Catholic faith. We have family values, the similar family values. I had a young family when I joined him. He had a young family. In fact, I think the encouragement came from a common friend of ours who lived across the street, the McCutcheons. I think Colleen and Jody were talking and said, hey, and my wife was, Leanne at the time, was a friend of theirs, and hey, why don't we think about Rick joining them? And John needed help, so it worked out great. So that was 39 years ago. And we're still a partnership, and I think a successful partnership. So I think you don't see it very often. And that's why I thought it would be important to comment on that, because how does that happen? It doesn't happen automatically. It happens with understanding of each other's goals, motivations, etc. Our goals and motivations were always to serve our clients. Our personal and philosophical goals may not have lined up, and our political alignment is like this. but you have to manage and try to stay away from the kind of conflicts that it's kind of like a marriage that would otherwise destroy it. So you have to have trusting, hardworking, honest partners and associates in your firm. You have to have people that you can get along with. Really pleased that Keith has joined us, been with us, and we made him a partner, and he's become a tremendous partner for us too. And the same is true of Pat, but of course he's moved on. The supportive staff assistants who know their jobs, appreciate their positions, and are happy to serve the firm and represent that happiness and contentedness, misspelled, sorry, in service to clients and messaging to the public. Your help when you got a private firm really are people out there who are representing the firm, and so it's important that they like you, like the firm, like their job, so they're not bad-mouthing you, and that does add to probably referral and many other things. We've always had very long longevity of our staff. We just had Nola Rordell retire last year after 41 years with us. Unbelievable. She's my age. We were graduated in 70 together from high school, and she her last name is Rock, and she was the Rock, and she left us last year, but after 41 years, and it's just amazing. Some law firms that are really stable. I know my friend Eric Thusen has had his main person with him for many, many years. I think maybe Bill has the same situation where if you've got a firm and you've been around a while, it's really nice to have those anchor people and who can train up new people. But we also always try to treat them well, bonus them, make them a part of things, involve them. And it's true with any support staff, even if you're in a government agency. I'm sure you find it that everyone wants to be appreciated. Everybody wants to know that they are important in their job and the job they're doing is important. I say freedom of attorneys to learn, improve their ability and service to clients. That's just a matter of not getting in people's way. As an employer, a boss, or a partner, it's always important to allow folks to develop their own. You're kind of guiding. In our firm, we discourage certain kinds of claim acceptance, and we do certain things, and we refer much out, and I'll talk about that in a minute. I'm talking pretty fast. By the way, if anybody had a question about anything I mentioned, throw your hand up. Happy to answer questions along the way. I don't know. I didn't really time how long it would take to go through this, but I will stop at the end and ask if there's any questions. But anyway, the freedom to come to partners, talk to them, not only the freedom in the workplace, but I think it's important especially in a general practice law firm that lawyers can go talk to another lawyer. Just feel like it's an open door. Call and ask it. We always had that. If you got a question, ask us, because we probably know the answer. We'll save you time. And if we don't know the answer, we'll call some other attorney who will know the answer. Building space that offers freedom of movement. We've been fortunate. Our current building has 2 floors and plenty of room, 3 conference rooms, so for mediations and things. And we do video depositions. We do focus groups in our building. We have plenty of room, and we also, I think, plenty of space and light for the staff and people to move around, because I think it's best when you can work at your office. I know a lot of people work at home, but especially when you're a firm and you're working together with people for the coordination, it's important. Although my hours and the rest of the firms are a little bit different. I'm the late arriver, and John's the farm boy that's in there at 7 every morning. But the promotion of reputation by consistency of performance at a high level for clients getting the best possible outcome. We always try in our business. It is about getting the maximization of a claim value for people, getting the most money for them from a claim. That's a lot of it is, but it's also a satisfaction otherwise too. We do pretty much personal injury work, which we're dealing with insurance companies and adjusters and their attorneys. So much of what we're doing is trying to be reputable with them, and that's important because we're going to deal with those same people. I know Progressive is a big presence here. We get a lot of Progressive claims, and their adjusters are fabulous, and I think part of it's because we've always treated them well, but they treat us well, and so there's this relationship. In our world, over the years, things have changed, and insurance representatives have moved out of state. I mentioned that farmers, and my friend Jim Higgins, he was in town when I came to town and worked in the 80s in this business. And then Ron Ashebrander was State Farm in this community and pretty much in this region. All claims went through him, all advances were through him, and he was it. But now State Farm, farmers have outside company representatives, and State Farm is all over the country pretty much. You're talking to people far away, and it's a different world. I think they're doing that for efficiencies, but you just don't have that personal relationship that you used to have. But nonetheless, they're still tracking firms who do claims, and if a firm doesn't do a claim or an attorney doesn't do a claim, they're going to know it. And so your reputation and how you handle claims is going to be what they look at, your track record, and in our business, whether you are willing to go to trial. That's huge. I mean, if you're not willing to try a case to jury verdict, the value of that claim is not going to be as good from the start. It's just the way it works in the personal injury world. So as far as intake goes, I think this is really important. If in any private practice, building client trust from the outset, but taking clients on and how you select clients or how you build your practice. We are at the point where we get a lot of referral. We get people off the streets. We were the back of the phone book ad people for a lot of years, so we got a lot of attention from that. We have a website now that we're trying to use to build practice, but a lot of it is feeder from past clients who are satisfied, attorneys even defense attorneys who have seen what we did and know somebody and said, hey, go to these guys. But you got to be careful about who you take on. So, and then once you take on a client, you got to build their trust from the outset. The first meeting with a client, they have to know that you know what you're doing. They have to know that you know it from start to finish. And there can be those folks who have their ideas of claims and values, and it can be important for a lot of reasons. One of them is that when those red flags go up about, hey, the first question they ask is, how much is this claim worth? Well, you know, that's one of those red flags. So along the way with clients, stay in contact with them, return their calls. I already mentioned that and let them know you're moving their things forward. In our business, when a person comes in with an injury claim, maybe they were badly hurt in a wreck, or maybe they come in months later and they've already been treating, and they finally realize that, geez, I don't want to deal with all these insurance folks. And it can be at any stage we get folks. We get folks close to the statute of limitations, which is 3 years, of course, for injury accidents. But at any stage they come in, we set up the file. We talk to them, though. We're very careful and cautious about taking claims that we feel, and this is a business practice, are going to be economically feasible, frankly. I mean, that we're going to not lose on, because claims, if they're smaller in value, I had a situation, a woman, my daughter referred a woman to me. We do a lot of slip and fall work, a slip and fall potential claim, and I just advised her what she needed to do, and it sounded like she had a really badly sprained wrist, couldn't use it for a week or so, probably going to be maybe a couple $1,000 type claim, or maybe in general's $5 at the most. If she heals up right away, it's hard to know and hard to value those. Everything's different. But every claim is based on the person and how bad that injury is, how long it lasts, and how much it interferes. Those are the three things, and I put those later in the outline. But every claim value, the real valuation is made, and I tell everybody on those three things. How bad is it? And the injury itself, and how long is it going to last? Is it permanent? Is it short term? And how much does it interfere? Because valuation of claims is done a lot on loss of course of life enjoyment because of the interference in your life ability to do things. So anyway, this person, I just said, it sounds like you're getting better. It's probably a temporary thing, and yeah, you've got your income loss, and if you want to put my name on the bottom of that letter, you're right to. It was actually the city of Helena, because it was a way that should have been de-iced, and she hurt herself on it, and your income loss and your meds. But I don't price yourself out of this thing until you know for sure that you're well, and a doctor has looked at it, and you've had a good examination to make sure there's not something else, because insurance companies and their adjusters love to resolve claims like that, and they are there with a check, and that used to be MO before the Unfair Claim Practice Act, was to really have the check right there and try to close claims out. But now they know that they have to be acting in good faith, and that slowed that down. But still, a lot of smaller claims, when we're selecting a client or a case to take on, we are very careful to make sure that ultimately there's going to be resolved economic benefit. I had a case where a situation, I didn't take it on, and it would have been a product case. This Binky I mentioned, some little child had, the Binky came off, swallowed it, and kid turned blue, went to the ER in Townsend, one treatment, they were oxygenated and fine. And they called and said, they wanted to make a big old claim. Well, I said, sorry, but your loss, I mean, I'm so happy that your child's okay, and I'm sure you are. And this was a really bad deal, or could have been a total disaster. Might have been a huge case if something more happened, but it didn't. So you got one bill. It's not worth it for me to pursue it, but I'll tell you what, make sure that you write every consumer protection outfit and notify them of this damn product so that there's people aware of this. And that's kind of one of the functions socially that we need to do in our practice, is to prevent dangerous things happening. And part of our practice is I like to think, curing some of the problems of and making the world a bit safer. I know it's self-serving for plaintiffs' attorneys to say that, but we really are safety measures are taken because bad products are out there. I had another funny story. My wife, when my son was born in the early 80s, they had these Kmart, you remember the wet ones you pull out, those wet ones, and they probably still have wet wipes, but Kmart had their brand, and it had this really hard plastic on the top of it, and my ex-wife Leanne had got her finger down there to pull it out, and it got stuck, and she could not get it out, and the finger was turning purple. This is kind of like the binky thing, and it was turning purple, and all of a sudden she tried to take it off, and I heard her screaming, and she's in the bathroom. It was early in the morning. She locked herself in and just screaming, and I said, well, let me in. So long story, finally I said, we got to go, let me see it. And it was turning purple, and she couldn't get it off, and any attempt to move it, it was stuck. So I said, we got to go to the hospital. We got to go to the ER. And coincidentally, when we got there, my John Dubeck's father, John Sr., was an emergency room doctor at the time there. His sister was the head of the nurses at the ER, and his wife worked at the ER. In fact, he was introduced to his wife by his sister, who's now a nun in a Catholic habit in teaching in Ohio, has been for about 30 years, but she was an ER. So anyway, John Dubeck Sr.'s there. We walk in, and she's got her robe on. She's got this plastic and these wet ones hanging from her. We walk in. It was a damnedest sight. And so he just took the sharpest scalpel he could find and cut around it and released the finger. And it was swollen for a while and went down and all that. But, again, we didn't make a claim, but I did, write it up and notify Kmart, notify the consumer people and anyone I could find that this is a bad deal. Small claim traps, I think the younger attorneys and Keith and Jonathan are benefiting from our having been down the road over 40 years with hundreds and hundreds of claims, and small and big, and you kind of learn what you think is sometimes not going to be a big deal becomes a big deal, and sometimes what you thought might be a bigger deal really doesn't pan out. And that's why it's so important to manage expectations on clients with valuations of claims, because we are very careful in a personal injury case to make sure that a person who's injured, that we don't resolve a claim until that injury reaches its point. It's called in work comp law maximum medical improvement. And that may be a year or 2 years if it's a back surgery or whatever it is. But it's really not ripe to settle an injury claim until that point. And so we will have claims in our office for years that aren't even litigated. This case I just resolved, I decided, because the adjuster was paying advance pay and doing well with that, I'm not going to litigate this. Plus, I thought my Exhibit A, my client, wouldn't be the best Exhibit A in the first place. So I just played it out, and we didn't litigate right away. But we wanted also to make sure that he had reached that plateau, and that way you know if it's going to affect their livelihood, if their injury is going to cause their wage loss in the future. Because in his case, it restricted him from doing heavy labor. We got what's called the functional capacity evaluation, which is done in work comp as well, they determine that this person is as good as they call it as far restored as the permanent character of their injury will allow, meaning that maximum improvement. Well, so a therapist is working with someone's soft tissue injury, and it's painful, and then they start reducing the visits, and they get them to a plateau where, yeah, you're still going to have this injury, you're going to have residuals, you might have flare-ups, but it's probably as good as it's going to get. So that's when you try to resolve the claims. In the small claim trap problem is that when you start litigating a case, there's costs, and we advance all the costs. John and I have been managed to do that with every case ever since we've been partners. And our partners before that, Floyd Small and Carl Hatch, I think did the same. We've never had a situation where we've said, okay, client, you're going to pay for these costs up front. And so we're running some money, and that's part of it. So when you're doing that, when you do your final breakdown, you're going to get a settlement amount. And if the settlement amount is the $25,000 policy limit, and they've paid 10 of it out already, there's 15 left, and your costs are at $5,000, you're taking a third fee, you might end up taking more than they're going to get. So, again, a smaller claim, you have to be really careful in our business managing what you take in. Minor injuries might be compensable. We never tell a person it's not compensable, just like that woman that fell. And I said, yeah, you should get your wage loss replaced. You should get your med bills paid. And if they're agreeable to do that and maybe throw something else on top of it, that might be fine. But I told her, call me back after you get the final word from your doctor on your wrist. If you go to a specialist, make sure that isn't a break or there isn't a ligament tear or something going on. And a lot of times, this is another thing that's evolved over the periods of time that John and I have been practicing injury law, is the orthopedic world has changed so drastically. In fact, I tell people, our office building was the first orthopedic clinic in Helena. Doctors Hansen and Bishop and Stemsrud, I think it was. There was another, and it was a medical clinic before that, but they were the first orthopedic doctors. Doc Hansen was the first private practicing orthopedic surgeon in Helena. That father of his son is now practicing in Helena. Now we have probably 15 to 20 orthopedic surgeons in Helena, St. Pete's and various groups. But anyway, that discipline started really in the 70s, and Doc Losey and Ennis, Montana developed the sling reef procedure for our anterior cruciate tears of the knee, and that was a breakthrough that basketball players were coming from all over the world to get that done, and that's been used. And all these different things have been learned. Well, and it's a continuum. So the reason I say that is that sometimes people have shoulder injuries, and then they find with a local MRI or whatever, even that MRI, I had a case where it didn't see the real tear, the tear that was causing the problem. There's MRIs that aren't effective in seeing that. You can do an MRI with contrast, which will show more. And so the MRI with contrast showed a tear that this person had been living with for a year that wasn't picked up. So my point is that the orthopedic world is always changing, and we deal with all those folks in that world. We deal with all the folks that deal with injuries, period. So the claim categories, in our personal injury practice and general practice, we have started focusing on just pretty much injury and have been doing that for probably the last 10 years. John, my partner John, taught business law at Carroll College for almost 30 years. He taught the business law class, and unfortunately it just got reduced to a semester class, and they brought somebody else, and much to his chagrin, and I was disappointed they did that. But they're doing some adjusting up at Carroll, and he's not doing it now. But so he knows a lot about businesses and business law, and he would troubleshoot a lot of business questions for people and do and he'll do complicated commercial litigation he'll do, and a lot of that sort of thing he's always enjoyed doing. He is the main doctor, lawyer in our firm that does the medical negligence claims, and we do quite a bit, and John does an amazing job. And if you look at the website we have, there's a ton of cases listed that he's handled, and he's handled a number since. I mean, every part of the body, and does just an incredible job handling those. Many of those aren't tried. Most of those are resolved. We do a lot of mediating work, and we've got our batch of mediators. In fact, he just resolved one last week. It was actually a failed nursing care fall case up in Great Falls, and Tracy Axelberg is one of our favorite mediators, handled that for him. So slip and trip and fall is really an important area. I have to tell a story, a very sad story that happened that I hearken to when I'm talking about how bad a fall can be for people. Fall injuries are probably some of the most serious injuries, and they're clear-cut injuries. Somebody lands on a shoulder, they have a tear, and ironically, I'm out there trying to make sure our folks that do our sidewalks are pretty good now, but when we were doing that on our own, I'd try to get out there with the salt. Well, actually, I had a second marriage, and my second wife was up the nail place and came around the corner and didn't have it iced, and sure as heck, bam. She didn't make a claim. She could have. She's got a really sore tailbone. But, bad things can happen on these slip and falls. In fact, here's an example of the very worst. We were a partnership when I first joined. It was Small, Floyd Small. He was in his near 80s. Hatch, Carl Hatch, John Dubeck, and myself. Well, Carl Hatch, Kurt knows him, and I'm sure Bill knows him, was a partner and did our estate and real estate practice, which we had then. He retired, and it was about I think he retired about 8 years ago, but about 3 years ago now in January, he and his wife have done mission work all over. They've gone to Burma. They've gone all over. Their Mormon church sends them on missions, and he's done tremendous work. Both he and his wife have. And he was doing some other legal stuff, and I guess he'd done a will for some lady, and his wife is delivering this over by the Capitol. And icy sidewalk, slipped, hit her head, had to be airlifted up to Benefice, and died that week through a clot and died the same week. So my point in that is obviously that falls are very serious. And there are comparative cases. In Montana, we have comparative negligence, of course. So you have a duty to watch where you're going. We all do. And yet, when a lot of times what happens is there's, these ice forms, and then there's light snow over it, covers up that ice, and somebody doesn't know it's there or just not taking enough care. And so those kinds of falls. But we've had all sorts. I ended up having, it's weird how things happen in batches. One year, I had 2 people fall through trapdoors. One in 2 different businesses, one in a bed and breakfast, one in a store. Just a trapdoor was open, and they walked and boom, went down. So any kind of falls and trip things, we do a lot of that. We, again, are scrutinizing every one, just like I talked about with that young woman's claim. Other negligence that we do is just, there's a lot of general negligence. We're also a work comp firm, and as Kurt knows, and we, over the years, have done quite a bit. When I first started with the Smith Law Firm, I actually had my first comp claim. A friend of mine who was at the Asarco plant and hurt his arm, and Jim Sewell helped me through it, and he'd done a little bit of that. But that firm was, as Bruce knows, I was writing school board opinions for the school association and opinions for the hospital association, which Chad Smith represented both organizations, and he was the lobbyist for them. Now I think they have droves of attorneys. But after that, I went around the corner, and in the 80s, work comp was a pretty big deal before 87, and the changes took place in 87 and kind of modified the law and set up mediations. But we still do quite a bit of that work. We're careful about what we take on. But here's a point that I like to make is that people that are in personal injury work, and someone's on the job, and some third party, for example, they're driving a car and they're on the job and they get hit by a negligent driver. Okay, that's a combined comp and injury case. And the firms that say, gee, I don't do work comp, I'll have to get somebody to do that for you, I think that's a real trap, frankly. And I've had a couple of those situations where I've taken over those. If you can't do them both, you shouldn't take on an injury comp case. You turn it over to somebody that does both, because it's really unfair to the comp attorney that you're trying to drag in, because you're going to peel off what is the better claim from the injury claim, and the harder work goes with the comp claim, babysitting, making sure their bills are paid, all the things that go into a comp claim. Just a word on comp claims over the years. I was just asking Keith, he said he was at the legislature last year, beating his head against the wall because it felt so good as a lobbyist for trial lawyers. But I did that for a number of sessions, and the 3 of us, the labor group and Al Smith, and maybe a few of us would be up there against, all the employers, the 5 insurance company attorneys from State Fund and all these others, and trying to make some impact on people who were always protecting employers. And it's a tough thing. But I learned right away that work comp, teaches you basically how to hold someone's hand. It's our work with clients is hand-holding. A lot of it's, I told you about building trust, but it's also having some empathy with your client, doing the best you can for them, but trying to understand their situation, where they're coming from, because there's a lot of emotion in it. Fortunately, when I first started, I did divorce work and some criminal work. And oh my God, any of you who work in DPHS and all those, all the family law issues are really tough. I mean, the people that do a heavy dose of that, I admire y'all, those folks that work in those areas. But the emotional part of what a practice, an injury practice, really came in comp because there's such a stigma for an injured worker. And back in the tort reform days when it was really heavy with ads and everything, it was harder for that person. They're losing their job. They're making 2/3 of their annual wage or their regular wage. They're hurting. They're depressed. They can't have relations with their family or their wife. And the world is telling them they're a scumbag for making a comp claim when, hey, I just want to go back to work. And it's a tough system. It's tough for those in it. I have to say the state fund here, I think, has done as good a job as can be done to manage claims. And I think they've come a long way with the management. I think Lanny's done a really good job administering the fund. Some of the problems we have are with administrators of claims. You have the Sedgwicks and the others that, like a town pump, will go to a third-party administrator, and those people are harder to get a hold of, harder to get their adjusters. But with email, it's been a lot easier. Okay, so we do a lot of comp. We did a lot of comp. We don't do as much. We have our referral sources, so we'll send some of those. SSDI, Social Security Disability claims, I did a number of those over the years, and we don't really do as many now. I've got a couple of folks I refer those to, and I think our firm all refer basically to these same people. And the point is that you can generate an attorney fee from a Social Security claim if you handle it through hearing and get a positive result, and it's limited to a certain dollar amount, and the percentage is 25% up to a maximum that's set on the back benefits, and you don't get anything from the future benefits. And in certain times that made sense. I got to the point where there was a lot of paperwork and office staff having to be involved in gathering all this stuff. And I had one year where I had 3 of those, and they all got shut down, and I thought they were all deserving. And it was just that the hearing officers were getting tougher, I think, on ruling on. And I thought, there's people that like to do this. We've got other things to do. So I walked away, and I've kind of encouraged the followers in our firm to not do them. Employment-related stuff, that's kind of goes hand in hand with injury cases. A lot of people have an employment discrimination or some kind of bad thing happen on the job, and they call us thinking, well, that's an injury and it's something we would do. We don't really advertise it much, but we do a certain number of those. Again, we have our people that we'll refer to. We think they do a good job, and we'll make referrals. Speaking of referrals, I think that any attorney who feels if they're in private practice on their own and a small firm and can't afford, and I've heard this at numerous seminars, that there are always attorneys there that would probably join up with you and support it if you have a big case and you don't want to get rid of it and help you with the cost, but they'll want to share the fee probably. That can happen. We haven't done that much. Jonathan King, who joined us, I was wondering, who is this guy with these billboards? He had the billboards on Prospect advertising personal injury. And it's always curious to me because whenever I see an ad or something or anything related to what we do, and it was John, and he was practicing on his own. He'd been a federal defender and was doing some criminal defense work, been around for a while, and he was officing in Eric Thuson's office, paying him some rent, and had a caseload. But again, I think when you're on your own like that, it's tough because you got to find out, people kind of aren't in a position usually to advance the cost of their cases, and to advance the amount of cost that you have to advance for sometimes experts or moving a case forward can eat you up, and if you don't have cash flow. We've been fortunate, John and I, we've worked hard. One of the first things I did to build the practice early on, and we have John's son working as a business manager for us, and I told him to tell this to the client. I have these exit interview when you give them the check when they've settled the case. I always say, we really appreciate you coming to us and being able to help you out, and we're really glad that we were able to get this result for you. Keep us in mind. If you have a family member, a friend, someone this is the area of practice we do, and if it was a slip and fall, I'd say, well, we do this, but we also do auto wrecks and deal with insurance claims related. and medical negligence, or any of these other things too, so that they're aware that we aren't a one-stop shop. We do all kinds of injury-type work. As far as in termination, Keith and I had a discrimination case, gender discrimination. We've had some of those kinds of cases in the firm. We've had the termination cases, again, it's an economic decision. You always, because of the tort reform and the economic damages after that have been established on termination cases where you only get 4 years of lost wages, you better have a pretty serious wage loss there. And people have a duty to mitigate, reduce their wages when they go out. So if they're fired, or they think it's wrong, or something happened, and it's not discrimination, and it's just a flat-out termination for not just cause, well, it might have some value, but does it have enough value for a person who's in our practice to take it? I just like to be honest with people, and I skipped over this thing about avoiding traps and being honest. Drives me nuts, the attorneys that say, I'm just too busy, or somebody calls me that they talked to an attorney or two and they said, well, they were too busy. They don't tell them you're too busy. Don't bullshit them. Tell them that it's not a good claim, or it's not a claim that's economical. I mean, be frank. I mean, if it's a claim, so I square with people and I say, hey, here's the deal. And maybe it sounds greedy, but we've got a lot of claims, and we're going to weed out and take what we can take. Doctors now, some of them are not taking Medicare, doesn't pay enough, It's unfortunately. My treating doc is not taking any more Medicare patients, But in our business, we have to be very careful about what we're using our time to do to make sure that eventually there'll be a payback, especially when you're in a contingency business. So we do autos, truck, motorcycle, liability limits. Insurance companies are insured, and that's what you're generally dealing with insurance. Once you hit the limits, I have had rare occasions where I try to take money from an individual or the person. I had a really bad quadriplegic case one time, and the young man had inherited part of a ranch, and we got some money from that in addition to the limits of the policy. But very seldom do I just, because people could file for bankruptcy, they're judgment proof, you're wasting your time. So, but underinsured motorists is a big deal. We had a successful appeal here in this courtroom. Pat handled it and did marvelously 2 times. It actually argued to the full 7 justices, the Malekush case, where I tried a case and won a verdict in excess of the limits. And underinsured motorist coverages claims are really important because in our state we have a $25,000 minimum limit. And I always tell people, it sounds maybe again self-serving, but carry a ton of underinsured motorists for your livelihood. That's a huge it's not that much to buy it. I got a couple million. I've got umbrellas on my underinsured, because someone who is, and usually it's the yahoo who has no insurance or has minimum limits, that's going to do the worst damage, going to crash into you, cause a severe injury damage. And if you don't have a pile of underinsurance or enough underinsurance, your claim is going to be diminished. So people had come into us with, we after, of course, you exhaust your underlying insurance from the negligent party, you go to the underinsurance, and it might be the driver's. The driver might be a part of a business. We've got a guy right now that it's a Virginia claim. I'm not handling the injury, but they've got underinsured on his insurance, the car he was in's insurance, and yeah. So, golden rule. We'll see. I already talked about the any questions by now? Anybody got anything pop in your brain that okay? The Consumer Protection Act, I've learned, is a very fertile field for claims to be made. I ended up defending it and had a trial a month ago, and we're waiting on rulings from Judge Minahan on fees, because they can get fees if they win on that. And we got a bike. I was defending Yacht Basin against a doctor who wanted to maintain a slip out there in the docks. It was a lease contract to slip his boat out there, and but the came back with an 8-4. Yes, Yacht Basin Fraser, you violated the act, but was there any damage or harm? No harm. So the judge had to give, under this act, $500, because you get your actual damages or $500, whichever is greatest. And so then you can also, with the discretion of the court, get attorney fees. And Kim Wilson is on the other side of this, and Scott Peterson. And their defense attorney, Paul Halfman, came in and was part of the trial as well. But the point is that that's thrown onto a lot of claims, and those guys I know do a lot of that work. I thought the thing was for banks and big companies and warranty companies and bad actors that way. It's been reduced to where any business who acts unfairly can pretty much have a consumer claim against them in addition to other claims. And it's kind of ill-defined, and we're going to find out how badly ill-defined it was in this case, because you've got to have a violation of public policy and one of these other things, unfairness, oppressiveness, whatever. And the jury actually came back with a question. What was the violation of public? They didn't know what the violation of public policy was. It really hadn't been defined in the case, and there was no instruction on what policy was violated by my person who has a right to contract. And we got the case thrown out on the contract because she had a termination at will agreement, but then got sued on the unfairness. Well, it's just unfair because you're retaliating, blah, 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 blah. Well, what policy is violated? Public policy there. So anyway, interesting case. Golden rule, in everything, in practice, treating people the way you want to be treated or feel like you would want to be treated. I mean, it's just human relations, client relations, office relations, everything. I mean, it's just, if you think that adjuster's a bastard or the defense attorney's a bastard, and you just take that approach throughout, you're never going to get anywhere. You got to treat people, like you would want to be treated. Again, firm and do your work, but not disrespectful. And again, truthfulness, trust established. I already kind of went over all that stuff. Moving claims forward in our business is huge. As I say, once the person who's had a permanent injury reaches max healing, it's time to resolve it. Some people push us. They say, if they need money and I'm hurting and I got to have this done. There's a case in Montana that's pivotal. It's called the Ridley case. You hear about it a lot. John Morrison handled a case for Keith Ridley to the Supreme Court, which established the principle that insurance companies under the UTPA had to advance pay medical. And they couldn't hold back on medical. And Keith was John's client. Well, Keith waited and waited and waited for a settlement on that case. I call myself the Ridley enabler because he came into me because his buddy was my client, and he brought him in on a second case, and he was pushing John to, I got to get that settled. And John called me and said, don't let him, tell him. I said, well, maybe I can get him some help on this second case. So I was able to, he had bills to pay, and the guy was being stretched out by the insurance company. Sure enough, a couple months later, that case came out. But the Ridley case, it does require that advanced pay of medical is to be done, and then Dubray followed it. And Dubray is about wage loss and other things, and so anything that is an automatic loss that relates, and you can show it's medically related to the injury suffered, they have to advance pay. So those have been great cases. Maybe not so great for, and we don't take a fee from those advancements. Some people do, and I don't think that's justified. Unless you had to work for it, they were refusing and you had to fight them for it. Our fee agreements usually, like the work comp agreements, that we have a state agreement to sign that says due to your efforts, attorney, you're entitled to what you earn due to your effort. And I kind of think that's the important part in a personal injury agreement as well when you're working for a client. Got a few minutes left. Our areas of practice, I just kind of listed all the areas there are that we refer folks out on estates and wills, bankruptcy, real estate. We kind of got our folks on all these. We used to do all of these things at some point in our general practice, but we've now limited it quite a bit. So we've got our group of people that we will send those out on. So I don't know if there's any questions. That's kind of what I had to say. I enjoy what I do, and John and I have been fortunate. We haven't had to go to the bank ever, and hopefully never do, to get a loan, because we just kind of just make sure that there's enough coming in and keep working on it. But personal injury practice is so rewarding. What we do is so rewarding because you're helping people, and that's kind of been our mantra. We help injured people, and you really are, because they're hurt, they're depressed. There's so many things that come into an injury in their life, and trying to understand that and what they're going through and helping them to get a result as quick as you can is what we do in our practice. And enjoyed it, and don't know how much longer I'll be doing it, but Keith here will be carrying the torch. All right, well, thanks, and have a great day. And, also, I would just say if anyone ever has a question of any area of practice, or a friend of yours has an area of practice question, and you're wondering who in Helena, anyway, is a good referral, we're happy to talk to people and say, hey, I've been around 40 years in this community. I think I know it pretty well. I'm kind of involved in a lot of things and have been over the years, both in practice and in 501c3 community. So I think I know. And then attorney-wise, it's always important to have somebody who's going to be fair to you, not overcharge you, get a good job, get a result, not drag things out. So I think we're happy always to refer. And we found that other attorneys around the state, Xander Blewett's one of my favorite people to call. If I have a question, a complicated situation, I'll call him. Insurance questions, the trial lawyers, we always call a Gary Zadok or a Jess Monroe, are the people that are expert in those areas. But everybody's generally really happy to be available. So, well, thanks for all you do, and thanks for listening. I didn't see anybody fall asleep. I didn't have to hand out any. I'm finished.